you so much for joining us today.
Susan took everyone through the metrics that we have in detail. Just a quick recap. Again, we have the 5 metrics: the independence, efficiency, effectiveness, predictability, and accessibility. But these terms are quite loaded and can be ambiguous, right? It can be interpreted in different ways by different people. And in fact, prior scholars have added nuanced definitions as they progressed in their work for each of these terms. So we have a bunch of ways to evaluate this in particular, just pointing out to how can we actually measure these 5 set of metrics. So that's what you are seeing in the third column. For instance, okay, when it comes to timeliness, we look at two modes of evaluation. Time to disposal of a case, age of the pending cases, and how long till you reach a first hearing, for instance. The last column, that's the tool. That is what this presentation will focus on, because we have deployed this framework using 2 tools, secondary data and survey, in order to demonstrate the approach that we've taken as to how this framework can be applied for a particular class of disputes. As Susan had mentioned in her presentation as well, there are some metrics which are amenable to be measured by courts data, whereas some are more, intangibles, or some maybe some litigants would prefer it, some litigants might not prefer it, but it's totally based on the perception of each litigant. For instance, how do you measure convenience? How do you measure fairness? So we also demonstrate how we use a survey tool in order to measure these intangibles. Okay, so first, how have we deployed the framework in order to measure those metrics that can be measured using secondary data? So out of the 5 metrics, 2 metrics can be measured through data. One is on efficiency, which is your timeliness aspect, and the second is on predictability, that pertains to hearings of the cases. We deploy this for 3 debt enforcement fora in Mumbai: the Bombay High Court, the Mumbai bench of the NCLT, and the Mumbai bench of the DRT. Oh. Okay, so how did we go about this? All our data was collected from the respective court websites itself. When you come to the Bombay High Court lists about 250 odd case types in its website. So we chose 4 case types: suits, summary suits, commercial suits, and commercial summary suits. Because based on our discussions and conversation with practitioners and lawyers, we realized that these 4 case types are most likely to have a debt component involved in it. Secondly, for the NCLT deals with insolvency and bankruptcy code matters, Companies Act matters, as well as your Partnership Act matters. The IBC is what deals with debt recovery aspect, so we picked IBC from that. Finally, you come to a debt recovery tribunals. The DRT is one of the oldest tribunal which helps in banks to recover loans and debt. So, and they deal with SARFAESI and the Recovery of Debts Due to Banks and Financial Institutions Act. So, as I mentioned, all 3 are taken from the website itself, but the website usually has different kinds of tabs through which you can search information. And they usually either put up case life cycle information in the case status or as daily orders. So we had to choose a method of going into the data in such a way that we don't have to give any inputs like the case number or the filing number, because we don't have any of that. So the Bombay High Court, we use the case status tab. For the NCLT, we use the daily orders tab. For DRT, it was a little bit trickier because the daily orders would just give us order PDFs. So we took the case numbers from the daily orders, input it in a different tab, and got the remaining case information. Okay, so as I don't have to say this, I think everybody in the room knows that data that's put up by courts are not frequent, incomplete, not uniform, etc. So just to maintain parity and comparability across the three fora that we are evaluating, we picked cases that were filed from September 2021 to December 2022. So that gives us about 5,000 odd cases, and the most number of cases is concentrated at the NCLT. So the second table gives us the percentage of disposed cases versus pending cases. That is, cases which were disposed of within this time period, filed and disposed of within this time period of 1.5 odd years itself. And we see that NCLT seems to have disposed the most number of cases, and the Bombay High Court and DRT are almost similar with 13 and 14% respectively. Now coming to using this data on our metrics. So the first metric, efficiency. So most of the prior work, at least with respect to Indian courts, that deals with measuring efficiency as a performance indicator, reports your aggregate workload of the court, what is the pendency of the court, or your disposal rate of the sample mean, etc. But this has two limitations. First, as we saw in the previous slide, pending cases make up most of the caseload of the court. So just reporting on the time taken by disposed cases could be misleading. For instance, when we looked at averages of NCLT, the disposed cases in NCLT take about 400 days to get disposed of, but the pending cases in NCLT are pending for more than 700 days. So that's more than a year difference between the pending cases and disposed cases. Secondly, it also misses out on the variation in the amounts involved and the complexity of the cases. For instance, easy cases, smaller value cases might be getting disposed of faster. So just looking at disposed cases will not give us this information. And finally, I think Susan also pointed this out in her presentation, just reporting averages or aggregates does not mean anything to a litigant who has a case in front of the court. So we use the survival analysis modeling approach. More details on the model and approach can be seen in our new article. I think we've sent it out to everybody. Using this approach, we answer two questions on timeliness that would matter to a litigant. Firstly, how likely is it to get a first hearing within the first year from filing the case? So we think first hearing is important because that's the first hearing. First hearing is when the judge actually applies his mind to the case for the first time. Your issues get framed. If the case is decided prima facie, then you get an interim relief or don't get an interim relief in the first hearing. So we measure the time to first hearing. And second, we measure the disposal. So how likely is it that the matter will get disposed within the first year from the filing of the case? So what do the numbers look like? We look at the chances of getting a first hearing within a 3-month period, 6-month period, and 12-month period. So if I can draw your attention to the 3-month period, if I'm a litigant and my case is in front of the Bombay High Court, the chances of me getting a first hearing within the 3 months is fairly low. It's just about 5.5%. However, you get the probability is the highest at the NCLT and followed by DRT. Now, if you look at the 6 months window, the probability of the litigant getting a first hearing in the Bombay High Court increases by almost 3 times. And if he's willing to wait for 12 months, then it increases to 40%. In the NCLT and DRT, on the other hand, on the NCLT, you almost will definitely get a first hearing if you wait for 12 months. In the DRT, it's close to 95%. Second, what are the chances of getting a disposal within a certain time period? So if you look at the Bombay High Court, it's similar to the first hearing that within 6 months of filing a case, there's a chance of 6% chance of getting a disposal at the Bombay High Court. So this is to I think, Amol's point, right? There are times when a matter is getting disposed of within one hearing itself. So that seems to be happening in case of Bombay High Court.
This 5.8% is of the total or of the 14.6% which are getting first hearing?
No, it's the total.
Right. So if 14 cases are getting heard in 6 months, of them, around 6 cases are being disposed of. That is what you are saying.
No, these are, this is a probability figure. So what is the probability of a case filed in Bombay High Court getting disposed of within 6 months?
So you have 100 cases, and there's a chance 6 out of them can get disposed. So the percentage is out of a base of 100.
Which is
So you can't do a case-to-case match. That's
okay.
So even, for example, it may be that a case has not got any hearing in the first 3 months, but still its likelihood of getting disposal is at 5.8% within 6 months.
No, I'm comparing 6 months to 6 months. So ऊपर भी 6 months वाला.
That's okay. Yeah. But so even if you compare the same timelines, you won't get a case-to-case match.
Okay. So this for the, again, NCLT fares better in terms of a disposal as well, where it does a 28.3% probability of a case in NCLT getting disposed of within 6 months. In the second column, you can look at how within a period of 1 year, what is the probability of a case getting disposed of. Like the jump from 3 months to 6 months, Bombay High Court seems to do that a similar, 3 times of the probability of 6 months is what it takes in 12 months. And while DRT seems to be very marginally moving. It moves from 11% in 6 months to 17% in 12 months. And by the time it goes to 15 months, even Bombay High Court seems to be catching up with DRT. Okay, the second metric, that is our predictability. So for measuring predictability, we compute the expected number of hearings for a case and how many of it were actually substantial hearings. Why do we do that? As Susan was also going through the intention behind putting this measurement, it gives the litigant certainty in planning her affairs and resources, and lawyers usually charge per hearing, so it acts as a proxy to cost. And finally, the opportunity cost for litigant to be in court present that day as opposed to being at her workplace or home, that can also get captured in terms of the number of hearings. So what do we find on the hearings? In the expected number of hearings within 1 year of filing for a case in the Bombay High Court is less than 1. For NCLT, it's about 2 to 3, and for the DRT, it's the highest at 4. So comparing our previous slides, and if comparing averages on aggregates, Bombay High Court has lesser number of hearings to get a case disposed itself in the first place. So in this metrics, if you have to decide whether having more number of hearings is actually good because you're then disposing of the case faster, or is it better to have lesser number of hearings, I think one additional point that becomes important in this consideration is how many of these hearings are actually substantive and how many are non-substantive. So for figuring this out, we did a micro study of about 600 odd cases, because this involved manual reading of each order of a case. We went through about 2,000 orders, and we took about 100 pending cases and 100 disposed cases for each court. So that's around 600 cases. And if you look at what percentage of total hearings of a case is a substantive hearing, it's about 40% for the Bombay High Court and 37 to 38% for NCLT and 41.6% for DRT. Almost similar for all 3 courts. And how did we make this classification? So if a particular hearing is termed as adjournment, or the case didn't come up for a hearing, or it was wrongly listed, anything to do with parties did not appear, technical glitch on part of the court, all that is termed as non-substantive hearing. And anything other than that, where a court issues a direction, where a petition is allowed, or if it's disposed, then we classify it as a substantive hearing. So just to explain this a little bit further, for instance, if the case has 5 hearings in DRT, then 2 of those hearings will be substantive and 3 of those hearings will just be your adjournments or non-substantive. Okay. So those were the 2 metrics that were measurable by secondary data. But as we all are now aware, not all metrics can be measured by secondary data. So as an alternative approach, we use a survey tool to measure the 5 metrics. We administered a survey to people who frequently deal with debt disputes. This included lawyers practicing in front of NCLT, Bombay High Court, DRT. Sorry?
Will it include these litigation funders like legal pay? I don't know if,
No, not right now. Yeah. In-house counsels of banks, NBFCs, partners of law firms, and partners at debt resolution, assistance in debt resolution firms, etc. So how did we go about the survey? We gave the participants a fictional problem, just so we can ensure that the responses are uniform, and we asked them to assign ranks to the Bombay High Court, NCLT and DRT on those parameters. We also gave them 2 additional courts as option, that is either metropolitan magistrate courts or also alternative dispute resolution, because more often than not, that disputes would include the agreement having an arbitration clause and a check. So for the survey, we included the following statements. So like I mentioned before, just saying how efficient is this code, how effective is this code would have been very ambiguous for a person taking a survey. So we pinpointed what we exactly want them to rate the code on. For instance, in case of effectiveness, we said once a judgment is pronounced by the forum, how easy it is for me to recover the amount that was mentioned in the judgment decree. Similarly, for accessibility, we did not focus on physical geographical access because right now it's almost hybrid. But we asked questions on is it affordable to resolve my case in this forum? How easy was it to physically navigate this forum, and so on and so forth. What were the characteristics of respondents? We had a total of 17 respondents. 15 of them were lawyers, and a couple of them were partners at corporate restructuring firms and debt financing firms. And most of them had appeared before the NCLT and the Bombay High Court. A little more than half of them had appeared before the DRT and had gone through ADR procedures. And we have the least representation from metropolitan magistrate courts. And the advocates we spoke to are practicing counsel for more than 20-30 years. And this is the final score sheet that we got based on the survey. So just to look at it one by one, because I understand that's a lot of numbers on a slide. So let's look at NCLT, right? So NCLT seems to be ranking the highest on efficiency. However, it's ranked the least, 0.61 on independence. So each of these metrics get a maximum of 1 point. So it's 0.81 out of 1. And the maximum score a particular court can get is 5. So on total, NCLT has gotten a score of 3.59 of 5. Now, if you look at the BHC on the other hand, it fares the highest on independence. That is, most people trust that the Bombay High Court will give a decision, an unbiased decision in their matter. And it seems to fare the least on predictability. Similarly, DRT seems, out of all 5, DRT seems to be doing the worst. And I think all the lawyers would just agree to it. And but they seem to be doing a little better in effectiveness than their other metrics. So if you are probably a litigant, if you are a debtor, and you have a bias that DRT being uh, taking care of matters under SARFAESI Act might be more creditor friendly, and NCLT scoring the least on independence maybe also more creditor friendly, then you would probably choose the one which you think will hear your matter unbiasedly, and that would be the Bombay High Court. So it really depends on, like we were discussing, what is the individual preference of each litigant. The ADR everybody seems to be giving ADR a good ranking, except in the effectiveness, because we really don't know how many that are actually settled outside go back into the system, like we were discussing earlier. Okay. So while we have compared these three codes, we also are aware and acknowledge that each forum have certain distinct attributes and features. For instance, the nature of remedies that's available, your NCLT is in the form of collective resolution process, your Bombay High Court is in the form of a civil suit, the proceedings may vary a little bit, etc. And second consideration is also the pecuniary jurisdiction. You cannot go to the Bombay High Court or the NCLT until your suit value is 1 crore. However, for DRT, you can go if it's 20 lakhs, but if you're not a bank, then you cannot go to DRT, for example. And finally, each court has its own organizational and administrative capacity bandwidth. Tribunals being directly under the government as opposed to your high courts. But our pilot is a demonstration of the approach that if all other things being equal, if more than one forum is available for a litigant, how does he make the choice? These are some open questions that we have, and we would love to have your thoughts on. Is how we have these two different data sources from which we have on which we've deployed the framework. How can we combine both these different sources in order to arrive at a composite measurement for these codes? We've done this analysis for a 1.5 years period, hoping that codes data has become better. It will become better even more as years progress. How will this analysis look for a longer time horizon? And this is just on debt disputes. There are more more pressing issues probably in terms of criminal justice system. How long is the bail? How long should I wait to get a bail? How many warrants are issues? Maybe those are important matters that we would like to consider as well. So how would this framework look for other types of cases? And I just wanted to also mention something that Justice Sikri was discussing, that yes, we also would like to, this is a diagnosis, yes. Reforms is the next, if you're asking if reforms is the point, yes. But even after you do the reforms, if we have to see if which reform is working, which reform is not working, you have to come back to this. So that's where, so this is not just a diagnostic tool. This is also something that we have to envision that will happen at a regular period of time, so that we can align the reforms to actually what the problems are. And yeah, I think I also wanted to talk about the substantive, non-substantive part that Anmol was asking with respect to, are they following the procedures of the court? So when we went through the orders, we saw that in DRT, if the other party doesn't appear, there are some judges which say, okay, go ex parte. But there are some judges which say, give one more adjournment, give one more adjournment, give one more adjournment. So I think for that kind of, yes, it will be good to see that. We would have to go through manual reading of the orders, or if we can come up with natural language modeling for all this, yeah, so that would be exciting.
I just want to say there's one more open issue, which is that this is just a pilot survey. So, I mean, all of this is a pilot, and the challenge for us is how do we increase the number of survey respondents from 17 to 17,000, right? The moment, the challenge for us is how do we scale it to a pan-India level such that this is way more representative than it currently is. The goal is to, let's just get everybody's feedback on whether this method makes sense, and then we figure out a way to scale it up.